Perfect. Well, welcome everyone. This is now the second session that we've done for this topic. Appreciate you all taking the time out of your day to listen in. We're going to have a brief sort of top-level summary of some of the key issues around businesses reopening, and I'm going to leave plenty of time at the end for questions. So if you do have any questions, let me know. I'd be happy to have a discussion about your specific concerns on the back end. So a little bit about our firm, McConville, Considine, Cooman, and Morin. We're a full-size law firm. We're based in downtown Rochester. We have 14 attorneys right now. We represent a wide range of clients, from individuals to small and mid-sized businesses to municipalities. Kind of that good fit for that middle market. We do have an office in Fairport at Packett's Landing. Because of the pandemic, all of our attorneys are generally working from home right now. If we do absolutely have to meet in person, we tend to prefer to do it in Fairport, where there's ample parking and it's very accessible for our clients. A little bit about me. I'm one of our trial attorneys. I primarily focus on civil litigation with an emphasis on personal injury claims. I also do commercial litigation and generally business disputes, whether it's collection matters or breach of contract matters. I help our clients solve problems. And I also collaborate with my colleagues on advising startups, small and mid-sized businesses as well. As an attorney, it's appropriate that I included a disclaimer in this presentation. As I mentioned earlier, this is going to be sort of top-level analysis for informational and educational purposes only. If you do have more in-depth issues, you need like some one-on-one counsel, please reach out to me directly. I'll leave my email at the end and be happy to do a consultation with you if that's something you're interested in. So I'm sure we've all seen the news as business owners about potential liability. There are potential criminal cases resulting from this pandemic. The Attorney General's office is currently probing Amazon workers in New York City because of the company's allegedly inadequate response to the coronavirus. There are also potential civil claims. Walmart was recently hit with a wrongful death lawsuit from the estate of a worker who died from coronavirus, again, alleging that Walmart is liable and responsible for the death of that worker. And we're going to focus on those civil claims for the bulk of this presentation because there tends to be a lower standard for those. They don't have to be proven by beyond a reasonable doubt. And a typical claim that you might see regarding coronavirus would be what's known as a negligence claim, where if someone's injured at your premises and they believe you're liable, they have to prove four things. The burden's going to be on the plaintiff to prove, number one, that a business has a duty. And generally, business owners have a legal duty to take reasonable measures to limit customers' exposure to dangerous conditions and at their places of business, and that's including exposure to infectious diseases. As part of a negligence claim, an injured party or plaintiff is going to have to prove that a business breached that duty and failed to take those reasonable measures. The third elements that a plaintiff has to show causation, that someone was injured because of that breach. And finally, an injured party has to show damages and that they were actually injured. Those can be economic damages, such as medical bills or lost wages, or they can be what we call non-economic damages, which would include physical and emotional pain and suffering. A typical example for a business in a negligence claim would be a foodborne illness, where if a restaurant or a food producer fails to follow proper safety standards and someone gets sick because of that, gets a salmonella outbreak or an E. coli outbreak, that business may be responsible for injuries that ensue because of that. This is a similar situation that we're dealing with now. Instead of a foodborne illness, you now have another form of communicable disease in terms of the COVID-19 coronavirus. So the same legal analysis would apply for a potential negligence claim. So the key thing that every business is looking at right now is what's reasonable. What reasonable steps should they be taking to protect their employees and their customers and guests? Unfortunately, there's no bright line rule, but the burden is going to be on the plaintiff to show what is reasonable here, and what attorneys are going to look to for both the plaintiff and defendant is what sort of mandated and recommended safety practices are in place here for potential claims. And they're going to look to sort of state guidance and different authorities, whether that be the CDC, the state, or local guidelines for what are general best practices, and also industry-specific rules for each type of business. Specifically, in terms of specific things that should be done in New York, every business is required to have a written safety plan outlining how they're going to prevent the spread of COVID-19. Whether you're an essential business or a non-essential business, you have to have a written safety plan in New York. There are templates available on the state's reopening website at forward.ny.gov. And every business, again, is going to be required to have this. Here's an example of a safety plan template on the Department of Health's website. This is just the first page. You don't have to submit them for approval. They do need to be in writing. You do need to have them on hand. And if there is an incident, the first thing people are going to ask for is, well, what's a copy of your safety plan that was in place at the time the incident occurred? What's a safety plan going to cover? Typical topics include what are you doing for your business in terms of physical distancing to keep people apart? What's your plan in place to provide your employees with protective equipment that needs to be provided at no cost to your employees? What's your plan for hygiene and cleaning? Your safety plan needs to include communication, including signage to instructions for your employees as well as guests. You need to be conducting mandatory daily health screenings for your staff. So that needs to be included in your safety plan. And then finally, your safety plan should include contact tracing and disinfection. You know, if there is a positive case, how are you going to let people know that they may have been exposed? And then also, what's your plan to clean your space to prevent the spread of the coronavirus? Along with a written safety plan, we recommend that businesses keep other records as well. A lot of attorneys like to say, well, if there's no record, did it really happen? So in addition to that written safety plan, you're already doing daily health screenings for your staff. We recommend that you keep a record or a written log of those screenings when they occur so you can prove that you actually did them. Along those lines, we also recommend records of your cleaning and sanitizing schedules. It can be a checklist indicating who did the cleanings on what day at what time. And then finally, contact tracing in terms of who's visited your place of business and what's their contact information. Again, this is going to be a test of reasonableness. So it might not be reasonable for Wegmans to keep the name and contact information of every person who walks in their store. But if you're a smaller business, you're only meeting with one person a day, it may be reasonable for you to keep some sort of records of who you met with so they can be reached if there is a potential exposure at your place of business. Moving along, we're getting a lot of questions lately about waivers of liability. Businesses want to know, can we have our customers sign some form just to release us and protect us? There are some advantages to having a waiver of liability. It can be used as a deterrent. Potential people who may have a potential claim say, well, I signed a waiver. I really don't have a case. I'm not going to pursue it. It can also be used as a shield, as a defense. We all are being exposed or risking exposure to this disease when we go out in public. That's what everyone knows. And if you have someone sign a waiver, you can put some of the responsibility on the incident on them. New York has what's known as apportionate liability, where a plaintiff can be partially responsible for an injury that occurs, whether it's 5% or 50%. Most defense attorneys will say it's 100%. You chose to go into the building. You're responsible for what happens. Having a waiver can put that in writing as well and can act as a shield. There are some drawbacks to waivers of liability. They're not always enforceable. Under New York law, under the general obligations law, it specifically bars waivers for recreational activities. So if you have a carnival ride or a skydiving business, you're not going to be able to waive it. New York has said it doesn't matter. You still need to take those reasonable steps and make sure that your facility is safe, regardless of any waivers that are going to be signed. You know, again, you may not ultimately need a waiver to argue a lot of these defenses. As I mentioned earlier, we know this disease is in our community, and you can have some sort of assumption of risk defense without a written waiver, because there may be some potential backlash for waivers. It may be, some consumers may say, well, why are they having me sign this waiver? Are they cleaning regularly? Are they doing the things they should be doing? Are they testing their staff? And it may raise some red flags for potential consumers. So that's a more practical concern to keep in mind if you're considering having consumers at your business sign a waiver. In addition to waivers, there's also some legislative protections in place. New York, as part of the recent budget, passed the Emergency Disaster Treatment Protection Act that essentially waives medical malpractice claims for healthcare providers during a public health emergency. It's very broad. It includes arguably facilities that aren't directly treating COVID patients, and it includes things like nursing homes. There may be additional legislation pending. Last week, the Republican majority just revealed the HEALS Act, and that contains widespread liability protection for all sorts of businesses and organizations regarding COVID-19. We don't know if that's going to be passed as written or if there'll be some back and forth with the House of Representatives. We're still monitoring that to see how that plays out, to see if there is additional protections at the federal level. There may also be additional state actions or local actions. Again, this is one of the areas that we're continuing to monitor. And in terms of legislative protections, there is also insurance coverage that may protect your business. Workers' compensation may protect your employees. If COVID-19 is considered an occupational disease, we believe it may be, so you may have protection if one of your employees gets sick through your workers' comp coverage. Your commercial or premises liability may also protect you for potential customers or consumers that may have a claim against your business. That coverage will provide not only an attorney to defend you, but also pay out any settlement or claim up to your coverage limits. And then finally, we've had a lot of questions about business insurance, which covers your lost profits if you have to close down because of this. Unfortunately, business interruption and coverage usually covers direct loss to your business because of physical damage, where a tree falls on your business, you can't operate, so the business interruption coverage would cover your lost profits. One issue. Number two, after swine flu, a lot of these policies added exemptions related to pandemics. So New York has proposed legislation mandating that these policies cover these types of losses. We don't think that's going to pass in New York. There's a very powerful insurance lobby, and they've been pushing hard back against New York state law rewriting the insurance agreements. So we don't expect that to be effectuated in New York. The one thing we're probably facing the most issues about recently is what to do about face coverings. I think every business owner has seen these viral videos about incidents with consumers making scenes in places of business, and businesses want to know what are their obligations here. So just to walk through how everything occurred, initially we saw an executive order number 202.17 from the governor, and that required face coverings when people are in public places and unable to maintain social distancing. That would include public places like within places of business. There weren't really any teeth there or punishments that within the executive order. The governor left it up to local enforcement authorities to try and enforce those. He then followed that up with Executive Order 202.34. And what that did was basically affirm that business owners, you have discretion to deny admittance to people who were not wearing face masks. That wasn't anything new. Businesses already had a right to deny service for any reason, as long as it's not a discriminatory or illegal reason. But that helps put that in writing for businesses to continue following that. And then finally, more recently, I think about a week ago, we saw from the Department of Health, they issued a new regulation that was much more affirmative, that required that businesses, it said they shall deny admittance and they shall require people to be removed from their business if they're not following that initial face masking executive order. And that can result in fines from the Department of Health of up to $1,000 per violation per day. So this is the most affirmative regulation we've seen in New York to actually compel businesses to take steps to enforce face masking in their places of business. Obviously, it doesn't compel you to physically remove these people. You have to deny admittance or ask them to leave. You know, our advice to businesses is to ask them to leave if they refuse to do so. Don't physically engage them or try to physically harm them. Call the authorities and ask them to intervene on your behalf to avoid, confrontation with you or your staff. All these across the board, all these executive orders and regulations have exemptions for those that are under 2 or unable to medically tolerate a face covering. People have concerns about the Americans with Disabilities Act. If someone claims they have some medical reason for them not wearing a mask, we get asked, does that mean we have to let them walk around our store unmasked and interact with staff and other customers? Generally, the answer there is no. Under the Americans with Disabilities Act, you have to provide what's known as a reasonable accommodation to them. And what's reasonable is from your perspective as a business. So if you're a real retailer and someone says they can't wear a mask or a face covering or a face shield, instead of letting them into your business, you could offer them curbside pickup, you could offer them delivery. If you're a service provider, you can offer them services by phone or by video. All those may likely be reasonable accommodations under the Americans with Disabilities Act. So this is a hotly contested area right now that people are very passionate about. And there's a lot of misinformation floating out right now, especially on social media. So I wanted to cite these specific provisions so people can go read the exact language that's in place, because there's a lot of misinterpretations out there right now. So, in conclusion, what are the key takeaways here? Our recommendation is that your business follow both mandatory and recommended guidance for your specific industry. There's a lot of great resources on the New York Forward website. We recommend that you take some time and review those and make sure you're in compliance. Every business should have a written safety plan, and it's not good enough to have a plan. You actually have to follow it and take the steps that you agreed to do in your own plan. And along those lines, document, make sure if you're doing cleanings, if you're doing testing, health screenings, make sure there are records of those as well. And then finally, in conclusion, you just need to make sure you stay updated and make revisions. From our office, it seems like we're drinking from a fire hose at times with a barrage of different rules and regulations coming out. I'm sure all of you feel the same way. So we need to stay on top of these and make sure we stay flexible. Following this presentation, my hope is that you all feel a sense of relief and you're doing a lot of the things that I just discussed. That's good. You're on the right track. If you're not doing some of these things, the good news is you can start with all of them today. They're relatively easy things like putting a safety plan together with a template or documenting the cleanings that you're already doing, and just to make sure we can mitigate potential claims, protect ourselves, our staff, and our clients and customers. So here is my email address as well. It's on the screen now, and I want to open it up to questions. If anyone has any questions, I'd be happy to take those now.
Yeah, I wondered on the screening. I mean, most of us aren't physicians. How elaborate is the screening needed to be?
So there are some templates, I believe, out there on the reopening website. They're pretty simple questions like, have you been diagnosed with COVID? Have you interacted with someone that's been diagnosed with COVID? There are temperature checks, so a gun thermometer to check people's temperatures. Our office has a one-page form that we use with those simple yes or no questions that you have everyone fill out every day when they come in. And it's one more step when employees sort of clock in. We ask that they fill out a survey as well and make sure that base is covered.
So you don't require them to take a temperature?
We do. Our office, we require people to take a temperature. We don't actually, they modified the rules recently. We don't actually record their actual temperature. We just want to know if it's above or below 100.4 degrees. So if it's above 100.4, they go home and we deal with it. Thankfully, our office, we haven't had that issue come up yet. But if it's below, then they go on with their day, and we know that they don't exhibit that one symptom of this disease.
All right, thank you.
You're welcome.
And Peter, in Gary's situation with students coming into the studio, they should be doing that with their staff as well as the students?
You should be asking, our recommendation is, it's a reasonable test. So I doubt you have thousands of students coming in every day. So if you're meeting with one student, to have them fill out a questionnaire, I think that's probably a reasonable and prudent thing to do for your protection as well as the protection of the students. I think a jury would think, yeah, that's pretty reasonable. That would help protect you as well. That's really from the business's perspective. It's about protecting you and your staff and mitigating potential claims. And, I always say, what's a jury going to think? So if you go in front of a jury and say, we had everyone that came in filled out a survey, no one said they had any symptoms. If they did, we asked them to leave. That seems like a pretty reasonable thing to do.
Peter, earlier on in your presentation, you listed 4 factors that have to be present. The plaintiff has the responsibility of proving those 4 factors.
Yes.
What's the chance that people are really able to do that? You know, is there a way for you to, I know you can't be specific, but it just, you know, is it something that would be easy for a plaintiff to do, or it would really require a lot of not only work, but a lot of causation evidence?
Yeah, causation is usually the biggest one. You know, damages, there's usually no dispute whether someone had a disease or didn't. That's kind of a black and white issue. Things like medical bills are pretty straightforward. Causation is the big one because people don't just go to one location over the course of 2 weeks and then come home. So what we see is it'd be similar to an E. coli or salmonella outbreak where plaintiffs and their attorneys would rely usually on government investigations, where if the Department of Health finds out that at this place, everyone that was there got sick, and they find the business and conclude in their investigation there was an outbreak there, then you know, as a plaintiff, that's pretty good evidence to go forward and say, I believe this is where the disease was caused. In a negligence claim, it's a lower standard than a criminal case. Criminal case, you need to prove it beyond a reasonable doubt. And a negligence claim, it's known as what it's called the preponderance of the evidence, meaning more likely than not. If the scales tip in just one way or the other, that issue gets decided in favor of the plaintiff or defendant. The good news is, as a business owner for defendants, it's also a preponderance of the evidence. So for that breach factor, if you can say we acted reasonably, we did X, Y, and Z, a jury may say, yeah, it's more likely than not that they acted reasonably and did not breach their duty to their customers. So that works for defendants as well as plaintiffs. So that's something to keep in mind as well.
Peter, you mentioned that that you've seen case come up with Walmart. Have you seen any cases even nationally coming up against smaller businesses or even some of the restaurants that have opened?
I have not. You know, locally we've seen more on the administrative side, especially for small businesses. I know the state liquor authority has been somewhat aggressive recently in terms of enforcing some of their rules and have threatened suspension of licenses. I've yet to see any businesses fined regarding masking, and I've yet to see any local civil claims. You know, thankfully in our region, we have what appears to be very low transmission, very low cases, very few deaths. So thankfully, we're not in what would be considered a hotspot right now. So I haven't seen those. You know, I think you're going to see the big claims at a lot of the larger chains because they simply metrics. They have many more people coming in and out. They may also have deeper pockets as well, large insurance policies. So it's almost a numbers game where if you're a large retailer, there's a better chance of exposure.
And how do you see the insurance companies handling lawsuits like that? You know, is it something that they'll go through also and see almost like they're judging the case themselves on whether or not they would take the claim?
They do. Well, I mean, typically your insurance company would be likely to defend you unless there's some sort of exemption there, but those are pretty rare. If there's a claim brought against you, usually your policy says that they'll cover you and defend you. And then they have their own metrics. They look at similar cases, similar incidents. They look at the injuries, and they have all sorts of different formulas. It's both an art and a science to determine, you know, where the case is valued, where it should end up. And that's done on the plaintiff side as well. Our office, we have access to a database, so we can look up other settlements, other jury verdicts, and use that to compare and come up with a ballpark estimate for what we're looking for our injured clients. You know, typically we're dealing with things like car accidents and slip and falls and things like that. It's more difficult with a novel. That's why it's called a novel coronavirus, because it's new. but you can compare it to things like E. coli and other diseases. Look at how long they've been hospitalized. Did they recover? Did they have surgery? I know certain cases have losses of limbs. So all those different factors would get reviewed on a case-by-case basis, and that's how they would look at typical exposure from an insurance perspective.
We live in a pool community, and our HOA board made the decision to not open the pool this year, to our chagrin. The insurance company involved said that if there was a lawsuit, they would cover up the HOA for the process of being challenged, but for any kind of compensatory monies for the damage that was done, the policy would not cover that. Do you feel that that's probably pretty true across the board of insurance companies?
Now that's surprising. Most policies cover cost of defense, and then they have what's known as bodily injury coverage, which would cover physical and emotional pain and suffering up to a certain amount. Other policies have specific coverage for medical bills. So, you know, it really depends on the specific terms of your policy. Each policy is written a little differently. You know, I'd be happy to review that if you'd like me to do so. But that's surprising, where they would spend money paying for an attorney to defend the claim, but not pay out any sort of settlement or jury verdict whatsoever. That sounds a little odd, and that's not typical. So I'd be curious to take a closer look at that if you'd like me to do so.
Okay.
It's funny you mentioned that. We did have another HOA with a pool, and they had residents sign one of the most broad waivers we've ever seen, essentially waiving them from any potential claim in the history of the world, including COVID. So, you know, that's one approach that these communities are taking as well.
In case a dinosaur would come and get them.
Exactly. Well, any other questions as we move into our afternoon? Well, I want to thank everyone for joining me today. If you think of something afterwards, my email is there on the screen. Feel free to reach out directly. And, you know, I know we all have a lot on our plates as small business owners, and we're wearing a lot of hats right now. And I think it was Gary or Mark mentioned it earlier. Hopefully this will eventually be over and we can move back to some sense of normalcy. So I wish you all the best. And then, again, any questions in the future, please feel free to reach out.